Recently, when talking with a client, she had just moved here from another state, and in the process of going through a divorce, she ran across this term community property. And she didn't know whether we were talking about a community center, a community swimming pool, or what we were talking about in the state of Arizona. And I had to spend some time with her explaining to her what community property is and what community property is not. When it comes down to divorce, yes, Arizona is a community property state. That virtually means this, that any property that is acquired during the course of the marriage becomes property to the community or the two parties. It belongs to the two parties. It becomes community property. That includes things like wages. If you're working a job, even though the paycheck comes in your name, your wages during the course of the marriage is considered community property. If you bought a home, the marital residence or a subsequent property elsewhere, rental property. So as long as that property was purchased with funds that were from the marriage, from employment or some type of asset from the community, it becomes community property. There's an exception to that. Say, for instance, you owned a piece of property, sole and separate property prior to the marriage. You sold the property and you intended that money to remain separate property. Then there could be some division of property. But broadly, anything that was acquired during the course of the marriage is going to be considered community property. That's income, properties, assets, boats, cars, jet skis, businesses, all of that stuff is going to be considered community property. This is important because the other party has an interest in community property. Whether the other party is a stay-at-home parent, whether it was income that they earned, it could be a retirement account, that is community property. It's a part of the assets of the community, and the other party to the divorce has an interest in that. And so you would want to keep track of all of those things. Now, gifts don't count, and there are certain other things, inheritances from family members, things like that can be excluded and be considered personal property, or property and assets that were acquired before the marriage remain personal and sole property unless they are converted into community property. And so you'd want to sit with the lawyer so they can delineate what's community property as it relates to your marital situation versus what's personal property, because this will all matter down the line once property is divided as the marriage is dissolved. So you would want to talk to a lawyer.